So today I'm going to focus on Medicaid planning. The title of this presentation is Your Estate Medicaid-Proof? And I think that may be a misnomer. What we're really looking to talk about today is Medicaid eligibility proof. So we're going to talk about some strategies to become eligible for Medicaid when the time comes. And there's going to be multiple opportunities to plan for that, whether that be now or whether that be when one spouse needs to go to the nursing home or when we're in what I call crisis mode. So I'm Michael Fleshman. I'm an attorney here at Woods & Bates in Lincoln. If you guys aren't familiar, we've got offices in Delavan and in Mason City as well. Right. So quick agenda for you. We just went through the introduction. I'll be discussing Medicaid Asset Protection Trusts. I'm going to refer to those as MAPs or irrevocable MAPs throughout this presentation. So that will be the Medicaid Asset Protection Trust. There are alternative strategies to a MAP or an irrevocable asset protection trust. We'll go over some of those alternative strategies as well. We'll go through the different Medicaid planning stages. I picked out three main ones that we see most commonly. Finally, I will talk about what the state does when somebody passes away to recover against somebody's estate that has been receiving Medicaid benefits during their life. I'll give you a couple of main takeaways and then open it up for questions. So with that, I will get started. So a MAP is an irrevocable trust. And it's key that it's irrevocable because that means the person that created the trust gives up control over the assets. Why is that control important? It's because whenever you apply for Medicaid or the state is determining your Medicaid eligibility, they want to know if you, as the settlor or the grantor, the person that created the trust, has control over those assets. By being irrevocable, you're giving up that control. So you can't decide where those assets are used, or those assets can't be used for your own benefit after you've created that trust. So you create the trust, which is a written agreement between yourself and the trustees. The trustee in a MAP or an irrevocable MAP cannot be yourself. So the person that creates the trust, like I said, is called the grantor or the settlor. So if you hear those terms, that is you, the person that is creating the trust and transferring your assets to the trust. So you create an agreement between yourself and the trustees. So who is the trustee? It's somebody that you trust, most importantly. Who do you believe can take on control of the assets that you've placed in that MAP? And who do you believe that's going to fulfill your wishes whenever you've passed away in accordance with your written trust document? So if somebody transfers assets to a MAP now and they need to apply for Medicaid, within the next 60 months, that transfer is going to be considered a gift, and it will be clawed back into your assets whenever you are filling out that Medicaid application. So the look back period in Illinois is 60 months, which is 5 years. When you apply for Medicaid, the biggest question on that application is, have you gifted, conveyed, or otherwise transferred any assets within the last 5 years? So by transferring assets into a MAP, you need to do that within or before 5 years passes when you would need to apply for Medicaid. So this is really the most advanced type of planning for Medicaid purposes. Usually people are doing this not at the doorstep of the nursing home, but rather years and years in advance. So when we talk about that look back period, you want to make sure that if you are creating this type of trust, you have a pretty good idea that nursing home care is not contemplated in the next 5 years. When you transfer those assets to an irrevocable map, you have given up that control over those assets. Your trustees will have direction on how to use those assets during your lifetime and what to do with those assets whenever you pass away. That trustee is going to have a lot of broad discretion over controlling those assets while you're alive, but they cannot use those assets for your own benefit, or it could break the irrevocable map, and then those assets could be includable for Medicaid eligibility purposes. So when you decide who your trustee or your trustees are going to be under your irrevocable map, you want to make sure first and foremost it's someone that you trust and someone that you've had a conversation with about this plan so that they are willing and able to take on that role if you do decide to set up an irrevocable map. So typically the assets that are transferred into a map are going to be financial accounts, investment, certain retirement accounts are eligible to be transferred into a map, and then also real estate can be transferred into a map. Typically, you're not transferring residential real estate into a map, and I will explain, or I'm sorry, your primary residence into a map, and I will explain that further later in the presentation. So one consideration when setting up a map is what assets do I transfer to it? All of my assets, a select category of my assets, and we can help you decide what's the most appropriate for your plan. Next, I'm going to talk about some other strategies to plan to qualify for Medicaid other than setting up an irrevocable map. So another strategy to complete or to become eligible for Medicaid is outright gifting. So you can gift outright to your beneficiaries or to your loved ones now before you need to qualify for Medicaid. However, the same 5-year look-back period is going to apply. So if you make a gift to your child today and you have outright, and the child owns that asset and has total control over that asset, then if you have to apply for Medicaid in the next 5 years, Medicaid will determine that you conveyed an asset and during that 5-year look-back period, and that you then become ineligible for Medicaid benefits for a certain period of time. The Medicaid ineligibility period is determined by the value of the asset that you transferred compared to the average monthly benefit that you would receive had you have been eligible for Medicaid. So Medicaid is a state administered program. There are caseworkers with the state that review Medicaid applications, and typically that's hand in hand with nursing home representatives or administrators that are helping families fill out that Medicaid application. Sometimes there are questions on that Medicaid application that are difficult to answer, and that's when you need to seek out some professional advice, because not all the time do nursing home employees or administrators know the correct rules of what is an asset for Medicaid eligibility purposes. So besides outright gifting, you can do other types of strategies to try to prevent assets from being used for your nursing home care. So one of those things is there's multiple real estate instruments that we can put into place that could prevent you from having to give up that control or outright gift the property to your beneficiaries. These real estate instruments that we're talking about, I'm going to focus on your primary residence. Your primary residence is excluded as a countable asset for your Medicaid application. So, for example, if you owned your home and you needed to apply for Medicaid, the state does not make you sell your house and use the proceeds from the sale for your care before Medicaid kicks in. As long as the Medicaid applicant has the intention to move home or return home, the state does not require that asset be liquidated and used for your nursing home expenses before Medicaid kicks in. So one way to transfer that real estate at your death and still qualify for Medicaid is something called a transfer on death instrument. It's a instrument that is like a deed where you transfer your real estate to beneficiaries in an instrument that gets recorded with the county, and it becomes a record that runs with the land of your property. So, for example, if you own your home and you want to make sure that it goes to your children automatically at your death, you could execute a transfer on death instrument. It gets recorded with the county, and then automatically at your death, the beneficiaries listed in that transfer on death instrument will be the record title holder for that piece of real estate. Alternatively, you can set up a living revocable trust. The revocable trust is something where you can be the trustee, you can have control over those assets, and you can benefit from the income of those assets. A living revocable trust is the assets owned by it are going to be considered countable assets when you apply for Medicaid. However, if your living revocable trust only owns your primary residence and you intend to return home to that primary residence, again, you do not have to have the revocable trust sell your house and use those proceeds for your nursing home care before Medicaid eligibility kicks in. When you transfer your primary residence to a living revocable trust, the trust is now the owner of that real estate. At your death, the trust continues to own the real estate, and there is a new set of instructions for your trustees as to what to do with that piece of real estate. So why are those things key when we're talking about Medicaid? So we'll go into a little bit of detail on the Medicaid estate recovery process, but the main takeaway from the real estate instrument strategy is that whenever somebody passes away and they have assets that have to go through probate, that's where the Medicaid estate recovery comes in. The state of Illinois will seek to recover the benefits that they paid for you during your lifetime through your estate. Your estate would be probated. There would be a chance for creditors to file a claim against the estate, and the state of Illinois would be a creditor in that scenario. So if you do a transfer on death instrument, or you do a living revocable trust that owns real estate, those assets do not pass through probate and then are therefore not recoverable through the Medicaid estate recovery process. Other strategies to preserve Medicaid eligibility or to plan for the need for nursing home care in the future could include long-term care insurance. Now, long-term care insurance may be more expensive now and your premiums may be higher now, but in the future, whenever you need to use that long-term care insurance, it's likely that that insurance policy pays your nursing home bill without the need for you to deplete your assets and then try to qualify for Medicaid. So we work closely with financial advisors, other professionals in the insurance industry regarding long-term care insurance when talking to people about planning for the need for nursing home care. We don't like to advise clients to go to the internet and Google what they can do to qualify for Medicaid, because there is a lot of information out there that is inaccurate. And so one of the main takeaways from this presentation is you need to seek out professional advice in whatever field you're dealing with and receive that professional advice directly from those individuals. All right, so we will talk next about your Medicaid planning stages. So what I've gone through so far is really the pre-planning stage, which is going to be well before the look-back period is even an issue. So we're talking well before the 5-year time frame is, or well before you're contemplating needing nursing home care, hopefully more than 5 years from the time that you established this plan. After pre-planning, the next stage is usually whenever you have a married couple and one spouse needs nursing home care, but the other spouse does not. So in that situation, there is a way for the community spouse, which is going to be known as the well spouse, or the one that does not need nursing home care, versus the nursing home spouse, which is the one that will be institutionalized. So during that type or that stage for Medicaid planning, you're looking at transferring assets from the nursing home spouse to the well spouse. And the state gives you some time to do that. So whenever a individual needs to apply for Medicaid or is seeking the need for nursing home care, they don't have to have all their ducks in a row necessarily when it comes to transferring assets to the well spouse immediately. There is a time period. It's 12 months after the date of the Medicaid application to get some assets transferred to the community spouse so that you don't have to spend down those assets before you qualify for Medicaid. Right now for 2024, the well spouse can take $154,000 worth of cash assets from the nursing home spouse, thereby depleting the nursing home spouse's assets and then having them qualify for Medicaid while still preserving a larger portion of the couple's estate. During that community spouse and nursing home spouse stage, we also take some steps to convert some of those exempt assets to the well spouse. So when you apply for Medicaid, there are countable and non-countable assets when determining Medicaid eligibility. Your non-countable assets include your primary residence, your primary vehicle, and then there are a couple other things that you can have as a non-countable asset. Everything else needs to be spent down before you can qualify for Medicaid. So for example, if you had a large investment account or a large retirement account and you needed to apply for Medicaid, you will need to spend that account down, or if you're at the stage where you have a well spouse living in the community still, you will start to transfer up to $154,000 of non-countable assets to, or I'm sorry, countable assets to the well spouse. The final stage for Medicaid planning is what I call crisis time. And that's typically when you have a single person that is now needing to qualify for Medicaid because they are contemplating the need to live in a nursing home. Crisis planning happens when you don't have a 5-year window to hope that there wouldn't need to be nursing home care in that foreseeable future. So crisis time means you know nursing home care is necessary And we then look at your assets and determine what is a countable asset for Medicaid eligibility and what is a non-countable or excluded asset for Medicaid eligibility. So excluded assets for Medicaid eligibility during crisis time, like I've discussed before, is your primary residence as long as you have the intention to move home. You can have a car, and there are some limitations on the value of that vehicle. We can go into depth in that if necessary. And then there are ways that you can prepay funeral and burial expenses, where you could take assets from those cash accounts and spend them so that they can be shifted into non-countable or excluded assets. So a hypothetical would be you have a single individual who owns their home, who owns a car, and maybe has $50,000 in the bank. You have to spend that $50,000 to a level where you are then qualified for Medicaid before the state will step in and start paying for your nursing home care. That dollar amount historically has been $2,000. You would need to spend down your assets, and you could keep $2,000 in the bank, and then you qualify for Medicaid. Just recently, in the last 6 or 8 months, the state has increased that amount from $2,000 to $17,500. So that's a drastic increase. But for my hypothetical, the individual that had $50,000 in the bank, they still have over $30,000 that they would have to pay for their nursing home care, private pay, before Medicaid would kick in. So what can that person do with that extra $33,000 under this hypothetical? Well, number one, they can prepay their funeral. They can prepay for their burial expenses. Number two, they can make improvements to their home, or they can pay off their mortgage on their home, so that that countable asset is now shifted to a non-countable or an excluded asset. So under my hypothetical, somebody could take that $33,000 and maybe put a new roof, new siding, new air conditioner, new furnace in the property. And as long as you've taken other steps to avoid the Medicaid estate recovery process, it's likely that you can increase the value of that non-countable asset and still preserve some type of asset to be transferred to your ultimate beneficiary. So now let's talk about, very briefly, the Medicaid estate recovery process. So when somebody applies for Medicaid and they are approved for Medicaid benefits, the recipient of those Medicaid benefits are sent a notice from the state explaining what happens when somebody is receiving Medicaid. When somebody passes away, that is when the state can pursue a Medicaid estate recovery action. And so commonly the state pursues that through the probate case for the deceased individual. So if somebody passes away, a Medicaid recipient passes away, and they owned their house, and they haven't put any plan in place to make sure that that house goes automatically to their beneficiaries, that house is by default owned by an estate. In order to get that piece of real estate transferred to the beneficiaries, you have to go through the formal probate process. So the formal probate process involves petitioning the court, publishing in the newspaper for creditors, and then allowing for known and unknown creditors to file claims against the estate. So when you probate an estate and the state of Illinois is aware that the deceased individual was receiving Medicaid benefits, you will most likely see an estate claim filed by the state of Illinois against the decedent's estate. So how do we keep those assets exempt from the Medicaid estate recovery process? Well, there's no foolproof way to do it, but we can make it more difficult for the state to have the ability to come in and recover those assets by removing them from the probate process and making them non-probate assets. So non-probate assets are going to include any bank accounts that have payable on death designations or beneficiaries listed. Exempt assets would also include life insurance policies that are payable on death to beneficiaries. And then your non-probate asset is also going to include real estate that is conveyed via transfer on death instrument, or if you fund a living revocable trust or an irrevocable map, those assets are not passed through probate. Those assets are administered through the trust without court involvement. So I will go now to the key takeaways from this presentation today. Number one is don't delay, start your planning now. Because all too often we see people come to our office and they are in crisis mode. We are not in the pre-planning mode. And unfortunately, there are not many things that we can do absent converting countable assets to non-countable assets in order to preserve some financial stability for that person's loved one without needing to spend down those assets to qualify for Medicaid. So if you take away anything from this presentation today, please let it be that you need to start your planning now, well before that 5-year look back period could become an issue. The other thing that I want you to take away is each family situation is unique. You have blended families, you have children that may not get along, you have children that may have spending problems, creditor problems. So there's not a one-size-fits-all plan when it comes to Medicaid planning. Each individual and each family is very unique. And as I've stated before, seek out professional advice in anything you do and trust the pros to advise you rather than relying on maybe some less reliable information. And so with that, I would open it up for questions from anybody.
Okay, Michael, I have a question.
Okay.
What kind of personal property is considered an exempt asset for Medicaid eligibility?
Okay, so when you're applying for Medicaid, you have your home, that's an exempt asset, and that's not your personal property. You have a vehicle that is considered personal property, that's exempt, but you also have household furnishings and your personal property and your personal belongings. So when we talked about ways to shift countable assets to non-countable assets, sometimes a strategy is, well, let's buy some nicer furniture for the home, or let's buy some updates to some of the personal property within the home. If you have like an ATV as a recreational side fund vehicle, that is going to be a countable asset that would need to be liquidated and the funds used for your private pay care before Medicaid would kick in. So your personal property, including your vehicle and your household furnishings and your household belongings, are going to be exempt when you're applying for Medicaid.
Thank you. Are there any horror stories from gifting assets directly to kids when Medicaid planning?
Yes, we just had one recently within the last couple of weeks. So one strategy as an alternative to setting up an irrevocable map is outright gifting to beneficiaries now and then hoping that look back period runs. Well, when you are contemplating making that gift, you need to ensure that whoever you give that gift to has your best interest in mind. And they need to know that they're receiving that asset so that mom or dad can qualify for Medicaid in the future, not so that that person can use those assets for their own benefit while mom or dad are still alive. And so commonly people will say, well, I want to get my house out of my name so that I qualify for Medicaid, and they gift their house outright to their child. Well, if their child has creditors or has a judgment against them, now all of a sudden your primary home that you have gifted to your child could be foreclosed on by your child's creditor. By gifting outright to a child, you also now shift that asset and it's being distributed under your child's estate plan rather than what you want.
So you can prepay a funeral, is that correct? And do you have to, I am at the stage of crisis mode with a parent, okay? And we were told, so she's gone through some assets, and we were told that she has like a $20,000 life insurance policy. And we were told she hasn't done anything with it yet. So we were told we can assign that over to the nursing home or to the funeral home as an irrevocable, but then Prudential, what that policy is with, says Illinois does not allow irrevocable. So how would it be better to cash that in and then prepay the funeral? Or do you have any information on that?
Is it a whole life policy that has a cash value?
Yes, it is.
Okay, so that's the difference there. If it's a term policy versus a whole life policy, there's different rules. There are, if it's a cash value type of policy, there is a cap or a maximum that you're allowed to then assign to pay for a funeral home type of an expense. So Illinois does allow for irrevocable life insurance policy type trusts. So in your situation, and it may be better to have a meeting, a private meeting about this, but in your situation, it's going to depend on the type of policy, the cash value of the policy, and then determining what to do with it from there. In the past, we've had clients that have named a funeral home as the beneficiary of a life insurance policy. We've had clients that prepay it directly, and that prepaid funeral contract is an irrevocable contract, and that is most certainly allowed in Illinois.
So it would be better then to go ahead and cash it in and prepay. I think the cash values may be 14. It may only be like I thought it was 20,000, but let's say it's 16,000 or something like that. And I think the cash value is like 14. So would it be better to, we were going to assign it over to the funeral home. So would it be better to cash that in then and then set it up as an irrevocable? So Medicaid can't take that? Or maybe I'm still not understanding.
Yeah, it may depend. If it depends on the type of policy, I would have to look at it and see what exactly is there before we can decide whether or not to cash it out and use the proceeds to prepay versus just assigning a funeral home as a beneficiary on that. Most commonly, it's a better policy if Medicaid, if the state says that this life insurance policy, the cash value of it is a countable asset and therefore needs spent down, then in that scenario, it's better to cash it out, use it for a allowable expense and deplete that asset that way and cover that inevitable expense without, leaving basically a funeral bill as the only inheritance for somebody.
Okay, but you could take assets currently though and prepay a funeral. Correct?
That's correct.
And then what would happen to that life insurance policy then? Is that assigned over to Medicaid then?
The cash value of it most likely would be determined by the state. And then if you didn't cash it out, it would create an ineligibility period where the state will say, depending on what your monthly benefit is, you are ineligible for Medicaid for X number of months. And at that point, then the family has to private pay during that ineligibility period. And then the state kicks in once that ineligibility period runs.
Okay. When we talked to a Medicaid person at the nursing home, she just said Medicaid likes it if you prepay that ahead of time, but we should probably get with someone to see the type of policy it is and if we should do the cash value or if we should assign it over.
Yeah, and at the end here, I could set up breakout rooms, and you can get in a breakout meeting room with either Kate or April, and they can most certainly get you on the schedule with somebody here at the office real quickly.
Okay, thank you.
I have one more question. Do my retirement accounts have to be used for nursing home care before Medicaid kicks in?
If you are the only one and you don't have a spouse, then yes. That is a countable asset, most certainly. And so a lot of time, the lion's share of somebody's assets are, investment accounts or retirement accounts, and those will need to be used for private pay nursing home care prior to Medicaid eligibility kicking in. The caveat to that is if you do have a community spouse, you can shift up to $154,000 to the community spouse from the nursing home spouse's assets. So most retirement accounts are individual type of accounts. So if you have the nursing home individual that has a retirement account in his or her name, then you can start transferring that asset to the well spouse so that the nursing home spouse doesn't have to spend all of that on their care before Medicaid kicks in. So there's another question in the chat. If a person has countable assets, would it be acceptable to spend down the cash by upgrading their vehicle? Yes, in most situations, you can upgrade the vehicle. There's a caveat that there's a maximum allowable amount as far as equity in a vehicle. And that maximum amount that the state provides is $4,500. But there's an exception to the exception that says if that vehicle is necessary for transfer to and from ongoing medical appointments, which most nursing home patients do have ongoing medical appointments, then the value of that vehicle, there is no cap on it. Well, thank you everybody again. And we're going to do a couple of presentations on Medicaid type planning. I plan to have an in-person presentation seminar sometime early June. And then depending how that one goes, we may do another Zoom webinar on the same topic or another in-person one on the same topic. All right, I'm going to end it. Thank you, everybody.